Hello everyone, this is Santosh Baliga and we are continuing with our lectures on company law. Today we will be covering the topics which is important from an examination point of view of meetings. Okay, the exact topics that we are going to cover today would be types of meetings. Okay, the second thing is requisites of meetings or essentials of meetings. The third part would be section 96, that is the provisions of this particular chapter from where it starts and it would end at section 121. But today we will be covering section 96 and section 97. Okay, so section 96 speaks about annual general meeting and section 97 speaks about power of tribunal to call for an annual general meeting. Okay, now the first thing is that a company is an artificial person, and hence all the decisions that are taken by the company are taken by a collective body of persons. Now this collective body of persons can be the board of directors of the company or even the shareholders of the company, and hence for taking these decisions the meetings are conducted in a particular company. Okay, so on the basis of this explanation there would be two types of meetings. One would be the meetings of the board of directors, which would be called as the board meeting, and the meetings of the shareholders, which will be called as the general meetings. Okay, the meetings of shareholders are called as general meetings. Okay, now for the purpose or scope of our syllabus, that is CA inter syllabus, we would be only covering general meeting. We would be only covering general meeting. Board meeting will be covered in CA final. Okay, so nothing to worry, we will only have to do this one topic. Okay, now coming back, there are two types of meetings. One is shareholders meeting, another is board meetings. Now, whereas shareholder meetings are also of two types, one is annual general meeting, and the other is extraordinary general meeting. What do you mean by annual general meeting? As shareholders are supposed to meet at least once in a year. And this once in a year activity of meeting is known as an annual general meeting. Okay. And then there is an urgent matter or something which the shareholders or the company cannot wait till the next annual general meeting. Hence, they will have to call for an urgent meeting. That meeting is known as extraordinary general meeting, which over here is depicted as EGM. Annual general meeting is covered under section 96, whereas extraordinary general meeting is covered under section 100. In today's session, we would be covering section 96, and in the next session, we would be covering section 100. Okay, so the shareholders meetings are of two types: annual general meeting and extraordinary general meeting. Okay, I hope you have understood both these type of meetings. Now, as far as requisites of meeting, that is the essentials which make the meeting valid. And if any of these essentials or requisites are not met, then the meeting would itself become void. And all the business that has been conducted in the meeting would also in turn become void. Hence, it is extremely important to understand these requisites. In the Companies Act, each of these requisites have been provided as a separate topic in itself, has been provided as a separate section in itself. During this journey of section 96 to section 121, we would be covering each and every one of these requisites in detail. So what are these requisites of general meeting? The requisites of general meeting are basically divided into three phases. One is before the meeting, second is during the meeting, and the third phase is after the meeting, which is called as, the first phase is called as properly call a meeting. Second phase is called as, that is during the meeting, it is known as properly convene the meeting. Convene means conduct the meeting. And the third phase is called as compliance is post meeting. That is the activities that you need to do as per law after the meeting. Okay, you understood three phases are there. One is properly call a meeting. This is before the meeting. During the meeting, it is properly convene the meeting, and the last after meeting is compliances post meeting. Now, these topics only I have listed over here. We will do it in our subsequent lectures. To properly call a meeting, what would we have to do before calling a meeting or for calling a meeting? We'll have to give notice to all the persons who are entitled to attend the meeting. Secondly, we'll have to inform them what are the resolutions that we are going to pass and what is the justification for the same. That is given in the explanatory statement. Okay. Now, whereas properly convene a meeting, the meeting has to be a minimum number of members have to attend the meeting. This minimum number of members, as per law, as per the Companies Act, is known as quorum. Every meeting has to be chaired by a chairman. That is covered under section 104. A particular member can himself in person attend the meeting or appoint a proxy or appoint any other person to meet or to attend the meeting on his behalf. That is covered under section 105. Every business which is passed in the company or decision is made in the company is by passing a resolution. And every resolution is passed by a due process of voting. So we would be covering voting and resolutions also in the further lectures. But these 5 topics would form part of the second phase, that is properly convening a meeting during the meeting. And the last phase is after the meeting, some compliances have to be done, like the minutes book. A minutes book has to be maintained by the company. All the proceedings of the meeting has to be recorded in the minutes book. And maintenance and inspection of documents is also a part of compliances post meeting. I hope the requisites are very, very clear over here. As we go into the further lectures, each and every component of these requisites will also be clear to you. So don't worry about that currently, like it is too much to do. It's not like that, it's very easy. Now we come out to our section 96, the first section of this particular topic. Section 96 speaks about annual general meeting. What is annual general meeting? A meeting of the shareholders held on an annual basis, that is once in a year. Obviously, this is held after the closing of the financial year. Hence, it is known as annual general meeting. So what does section 96 says? Section 96 says an AGM would have to be conducted by a private company or a public company on a yearly basis. An OPC, which is a 1% company, has been exempted from such provision. Why? Why is the OPC exempted? Because it is a single person in a company. Only one member is there in a 1% company. And for a meeting, you would require at least 2 or more persons. Okay. Now, so company, be it private company or public company, they need to hold an annual general meeting. Secondly, whenever a company conducts an AGM for a particular year, then the gap between 2 AGMs, that is the AGM for this year and the AGM for the next year, the gap between these 2 consecutive AGMs shall not be more than 15 months. Shall not be more than 15 months. So gap shall not be more than 15 months. This is important from your MCQ purpose. Okay. I hope this is clear. So the gap between 2 meetings shall not, 2 AGMs shall not be more than 15 months. Okay. Now, what is the period within which an AGM should be held? What is the period within which an AGM should be held? Now, in case the AGM, I'll classify this into 2. One is the first AGM, the other is subsequent AGM. First AGM means an AGM held in the first year of an incorporation of the company. So that is covered over here. The first AGM shall be held within 9 months from the date of closing of the first financial year. Okay. And in case of subsequent AGM, It shall be held within 6 months from the date of closing of the financial year. I hope this is clear. Let me give you a small example for you to understand this more. In case a company, say A company limited, it may be a private company or a public company. They will have to hold an AGM. Okay, and this AGM has to be held. Say if it is a first AGM, if it is a first AGM, company is incorporated on 31st of December 2019. So its financial year will close on 31st of March 2020, and hence the due date for the AGM would be 31st of December 2020, which is 9 months from the end of the closing of the financial year. I hope this is clear to you. The second concept that we saw was in case of subsequent AGM. Subsequent AGM. Again, the financial year will end on, the next financial year for this company will end on 31st March 2021. Okay. Now, in case of subsequent AGM, you get a deadline of 6 months from the date of closing, which means you will have to conduct the annual general meeting within 30th September 2021. So I hope both these concepts are extremely clear. In case the company is not able to hold due to genuine reasons like flood or COVID situation or something like that, then they can apply to the ROC. And ROC can, in special reasons, extend this period by 3 months maximum. Okay, I hope these all provisions are clear to you. We'll go back to the presentation. And over here in the presentation, first AGM, subsequent AGM, we have already covered. And the next point that I was illustrating in that particular example was the registrar may grant extension by 3 months for special reasons, except in case of first AGM. So no extension for the first AGM. No extension for the first AGM. Extension can be sought in case of subsequent AGM. Okay, I hope these concepts are clear. Next, when, where shall the AGM be held? The AGM shall be held during the business hours of the company. What are the business hours as per Companies Act? It is 9 a.m. to 6 p.m. Okay. The AGM shall not be held on an national holiday. Okay. National holiday is national holiday as declared by central government. Very simple. So AGM cannot be held on a national holiday. Second point, AGM shall be held only at the registered office of the company or some other place within the same city, town, village in which the registered office is situated. So the place where the AGM can be held is registered office, or any other office where the registered, or any other place where the registered office of the company is situated. But in case the company is an unlisted company, then it can hold at any other place by writing or electronic mode by all the members in advance. All the members means what? This is about unanimous consent, which means 100% members shall give in writing. Then an unlisted company can hold the AGM at any other place. Okay, I hope this one is also clear. And the last point over here says that central government may exempt any company from the above provision subject to conditions as it may impose. Clear? So going back to illustrate the same thing, AGM shall be held during which hours? Business hours, which is 9 to 6, 9 a.m. to 6 p.m. As well as the AGM shall be held at registered office of the company or any other place where registered office is situated. Okay, as well as if the company is an unlisted company, if the company is an unlisted company, then it can hold anywhere, any other place, but in India only, provided all members consent in writing or electronic mode in advance. I hope this is clear. In case the company defaults in holding the annual general meeting, what is the remedy which is there to the members? Any member of the company can go to an tribunal and apply for the tribunal to exercise its power. What is the power that the tribunal is having? So, in case a company defaults in holding of AGM under section 96, then on application made by a member, only a member of the company, the tribunal may call or direct AGM of the company and give such ancillary or consequential directions. Also, a point to be noted over here is that tribunal may even give directions which may include that one person present shall also be deemed to constitute a meeting. I hope this point is also clear to you. This is a small provision, not very important provision, but do remember in a case study, they might ask you in the case that a particular company, what is the due date of within which a company has to hold an AGM? This second part of the question may be, if the company does not hold the AGM within the given prescribed time limit, what is the remedy available? So you will have to then write section 97 in this case. I hope this is clear. Now there are a couple of examples which are given in ICAI modules, your institute modules. And these are very simple examples, but let us go through it. The first example is Abyss Private Limited closed its financial year on 31st March 2018. Now your answer for this particular question shall be, you would first explain section 96 and you will illustrate or you will give the provision regarding first AGM as well as subsequent AGM. As over here in the question, it is not specified whether it is a first AGM or subsequent AGM. So obviously, if it is a subsequent AGM, then it has to be within 6 months of the closing of the financial year. And if it is a first AGM, then it shall be within 9 months. So here the answer given is 30th September 2018. In the second example, Abirish Limited was incorporated on 11th December 2016. So when shall it hold its AGM? So this is a clear case where it is about first AGM. And over here you will have to write within 9 months from the date of closing of the financial year, first financial year. So it can be held within 31st of December 2017. I hope these two examples are clear over here. So this is the end of this particular session. I hope you have understood all the topics that we have covered today. I would be coming up with the subsequent topics also very soon. So stay tuned to this particular channel, subscribe to the channel, like this video, and share the video to as many people as possible. Thanks a lot.